But just because she behaved that way doesn't mean that she killed her child.
Glass after glass of that ultimately killed him.
I never thought it would kill him.
This man.
In 2019, Jamarcus Howard tragically lost his life in Tampa, Florida. His mother, Shirley Hunter, had been dating Enrico Adams for about 4 months at the time. According to prosecutors, Hunter left Jamarcus alone with Adams while she went to a laundromat. When she returned, the baby appeared to be asleep in his crib. The next morning, she was unable to wake him and immediately called for help.
And you said that Jamarcus was very cold?
Yeah.
Jamarcus was rushed to the hospital where he was pronounced dead. A medical examination determined that his injuries were severe, leading to an investigation into what had happened while he was alone with Adams.
It's the only time the defendant was ever left alone with Jamarcus Howard, and he ends up dead.
Hours before the incident, Jamarcus appeared healthy and without any injury in surveillance footage.
The circumstantial evidence in this case is overwhelming, and it is strong, and it leads straight to that man's guilt.
Authorities arrested Adams and charged him with first-degree murder and aggravated child abuse. The case first went to trial in June 2023. During the proceedings, Adams' defense team attempted to shift blame to Hunter, citing a text message where she allegedly expressed frustration with Jamarcus.
Punches could have caused these injuries. Who's talking about punching that child? Who's talking about hurting that child? It's not Enrico Adams.
They also argued that Hunter displayed little emotion on the stand, suggesting this could indicate guilt. However, prosecutors countered that her demeanor did not make her responsible and that circumstantial evidence overwhelmingly pointed to Adams.
But just because she behaved that way doesn't mean that she killed her child.
The jury failed to reach a unanimous verdict, resulting in a mistrial during the first trial. Prosecutors pursued a retrial, and in October 2023, a second jury found Adams guilty on all charges. Following the conviction, Adams was sentenced to 2 consecutive life terms without the possibility of parole. Richard Miller was convicted of first-degree murder in the death of Renee Williams, a home caregiver and teacher's aide. Prosecutors argued that Miller was unable to accept the end of their relationship, and his obsession and jealousy led him to commit the crime.
This is a case of obsession, ladies and gentlemen. Richard Miller was a man obsessed. He was obsessed with the victim in this case, Renee Williams.
Prior to the incident, Miller sent Williams a threatening text.
Never play with a person. They're dangerous.
Prosecutors claimed this was a clear indication of intent, which he later acted upon. On the day of the crime, Miller allegedly waited outside Williams' workplace at an apartment complex, armed with a loaded gun. When she arrived, he confronted her and fired at her.
It drove him to take her life rather than to let her go on without him.
A resident testified that he heard shots and saw Miller calmly walking away, tucking what appeared to be a firearm into his pocket.
He was walking towards my right.
Where did he have the gun when you saw the gun?
He had his right hand putting in his pocket.
However, the defense argued that there was no physical evidence linking Miller to the recovered firearm, stating that scientific testing failed to prove it belonged to him.
The firearm that was found there cannot be placed in Richard Miller's hands by any type of objective scientific evidence. Richard Miller is innocent.
They maintained that he was wrongfully accused and had no involvement in the crime. Despite the defense's arguments, prosecutors presented additional evidence, including a reported confession from Miller. After deliberating for nearly 2 hours, the jury found Miller guilty of first-degree murder. He was subsequently sentenced to life in prison. Matthew Terry was convicted of the murder of his girlfriend, Kay Baker, after a violent confrontation at their home in Lithia, Florida. Authorities stated that Baker was attacked while attempting to escape during an argument, and Terry was later found hiding in the bushes and arrested. Initially, former state attorney declined to seek the death penalty, but after governor suspended him and appointed state attorney Susie Lopez, the decision was reversed. Terry's defense team accused Lopez of political bias, claiming the change was influenced by partisan politics.
The Democratic state attorney makes one decision, 24 hours later, a Republican state attorney makes a different decision. And we're going to say that's not political. How is that possible?
Lopez denied the allegations, emphasizing that Terry's actions were particularly cruel and justified the harshest punishment.
Ms. Baker, as Mr. Diaz had said earlier, was nearly decapitated when the knife that Mr. Terry plunged into her throat.
Prosecutors highlighted Terry's history of violence, pointing to a previous conviction for stabbing his ex-girlfriend, Michelle Rogers, in Michigan. Rogers, who survived the attack, testified that Terry had attacked her, which led to his 3-year prison sentence.
Did the judge eventually sentence Mr. Terry to prison for this case?
Yes.
Before Terry's trial, the court ruled that the jury could hear about this past conviction, allowing prosecutors to establish a pattern of violent behavior. During the 5-day trial in November 2022, a Hillsborough County jury found Terry guilty of first-degree murder. In the penalty phase, the same jury recommended a life sentence without the possibility of parole, which the judge later imposed. Following his conviction, Terry sought a new trial, arguing that his attorneys misled him into not testifying on his own behalf. However, the court denied his request, upholding the original verdict and life sentence. In 2015, Dee Dee Blanchard was killed in her Springfield, Missouri home. Investigators later learned that her daughter, Gypsy Rose Blanchard, had conspired with her boyfriend, Nicholas Godjon, to carry out the crime. For years, Dee Dee had subjected Gypsy to medical abuse and extreme control, falsely claiming she was severely ill to gain sympathy and financial support. Seeking to escape, Gypsy met Godjon online, and the two eventually plotted to kill her mother. Following their arrest, Gypsy pleaded guilty to second-degree murder and was sentenced to 10 years in prison, citing years of abuse by her mother. Godjon went to trial in 2018, where a jury convicted him of first-degree murder. He was sentenced to life in prison without parole, plus 25 years for armed criminal action. Since his conviction, Godjon has sought a new trial, claiming he lacked the mental capacity to understand his actions. Tyler Coyle, the new attorney of Godjon, believes that his trial attorneys failed to provide effective representation.
Mr. Godjon was alleging that the only reason that he was found guilty in his jury trial was because he had ineffective assistance of trial counsel.
The defense argued that Gypsy Blanchard manipulated Godjon into committing the crime, citing neuropsychological evaluations to support their claim.
I used the one card that I have over you. Gypsy.
However, a previous appeal was denied, and his conviction was upheld.
I'll admit it. I did actually.
In December 2023, the public defender filed another appeal.
Last trial, he argued that his mental state did not meet the requirements for first-degree murder, and so the jury should have only found him guilty of second-degree murder.
The appeal claims important evidence about his mental condition was overlooked, which could have influenced the jury's decision. The case is now being reviewed by a panel of 3 judges who will decide if Godjon qualifies for a new trial.
If he were to get a new trial, then it would start all the way over, and there wouldn't be any previous finding of first degree or second degree. It would just have to go back to a new trial.
If granted, the case would start over with no prior rulings influencing the outcome. There is no set timeline for a decision. Meanwhile, Godjon remains incarcerated, while Gypsy Rose Blanchard was released on parole in December 2023 after serving 85% of her 10-year sentence. The tragic events unfolded at Borders drive-thru on Arlington Street in Akron when Daquan Isaac attempted to purchase a single cigar. As he handed over money stained with blood, Ahmad Al-Ibrahim, the drive-thru worker, refused to accept it, leading to an argument. Moments later, Isaac fired a rifle through the drive-thru window, fatally wounding Ahmad. Following the incident, authorities arrested Isaac, charging him with murder and felonious assault.
My heart, and I'm not forgiving him.
أنا ما سامحه وبتمنى من الجميع ما حد يسامحه.
And I wish nobody forgives him. What did Ahmed do against you?
Nothing at all.
ولا شيء.
شو في بينك وبينه؟
What was between you and him?
Nothing at all.
أنت بتعرفوا شيء؟
Do you know him?
No.
During the trial, Ahmad's mother confronted him through a translator, demanding to know why he had harmed her son, someone he didn't even know.
And also that he did not kill a person, but he killed the whole family.
Ahmad's father, who had moved his family from Syria to the U.S. in 2017, shared his heartbreak, explaining that they had escaped violence in search of peace, only to face unimaginable tragedy.
We came to America for peace. We ran away from a war-torn country to find peace here.
I plead guilty to that charge. When my brother was taken away, I told myself I would never do that to another human being, and it turned out that I turned around and did the same thing. I apologize to the family. It was a senseless act, unjustified, inexcusable.
Isaac, in a moment of reflection, admitted that his own brother had been murdered years earlier. He recalled vowing never to inflict the same pain on another family, yet ultimately he did. Ahmad's family expressed doubt about his remorse, believing that beyond the courtroom, he would still face judgment for his actions. Isaac pleaded guilty to murder and felonious assault and was sentenced to 18 years to life in prison. The case surrounding the Blow Hookah Lounge incident in San Antonio led to the arrest of 6 individuals in connection with the tragic death of Takhai Michael. Prosecutors stated that a group approached Michael's car, where he was with his girlfriend and 2 friends. The situation escalated, and Michael suffered fatal injuries.
What happens after that is really quick. You have 5 other men, many of them armed, well armed, who approach that vehicle and all play a different role.
Surveillance footage allegedly showed Tajarina searching through Michael's belongings after the shooting.
Goes over and rifles through this dead man's belongings. You're going to see that on video. It happens really quick, but it is absolutely chilling to watch.
Tajarina's defense maintained that he was merely talking to someone in the vehicle and had no involvement in the events that unfolded. His attorneys pointed out that no video evidence showed him possessing a weapon or taking anything from the victim.
Also, they saw Jonathan Tajarina with a handgun, okay? But you're never going to see that handgun in the video. Never going to see a gun in Jonathan's hand.
After reviewing the case, a jury acquitted Tajarina of all charges in July 2024, determining that while he was present, he did not participate in the crime. The other individuals involved accepted plea deals for lesser charges. Aaron Matthew Trevino pleaded guilty to murder and received a 50-year sentence. Nathan Cruz Sanchez pleaded no contest to murder and aggravated robbery, receiving 35 years. Arturo Alan Reyes and Andres Villarreal both pleaded no contest to 2 counts of aggravated robbery, each receiving a 20-year sentence. Robert Joseph Ortiz agreed to plead guilty to aggravated robbery and is currently awaiting sentencing. With most of the defendants sentenced, only Ortiz's final court ruling remains pending. In 2018, Shakayla Denson was arrested in Tampa, Florida, for the tragic death of her daughter, Jahaira Daniels. Surveillance footage from a used car lot showed Denson walking with Jahaira shortly before the incident. Prosecutors argued that she intentionally drowned her daughter in the Hillsborough River, while her defense team initially planned to use an insanity defense, claiming she was unable to understand her actions. The case faced several legal delays. Prosecutors sought to have medical trainees observe Denson's psychiatric evaluation, but the judge ruled against it, stating it was not appropriate for educational purposes.
This is a case where Miss Denson is accused of being her autistic daughter, and, it is not a teaching tool for the state's expert.
Additionally, her attorneys challenged a confession she allegedly gave to child protective investigators, arguing it was improperly obtained.
Subpoenas are not invitations.
As the trial date neared, prosecutors requested a postponement, citing a key witnesses' scheduling conflict.
She is going on a pilgrimage. This trip to Europe has been postponed due to COVID for 2 years.
But judge denied the request, saying the witness had been given enough time to prepare.
1 day out of her life, we've given her 6 months notice that she's going to need to be here for trial.
Before the trial could begin, Denson pleaded guilty in May 2022 to second-degree murder, aggravated child abuse, and grand theft. Her plea allowed her to avoid trial, and she was sentenced to 20 years in prison. In April 2018, a road rage incident in Tampa, Florida, led to the death of Gilbert Cerna. According to reports, Cerna, a passenger in a utility truck, spat out of the window, and the spit landed on a black BMW driven by Teddy Baltimore Smith. This escalated into a confrontation, during which Smith allegedly Serna. After the altercation, Smith fled the scene but was arrested days later. In August 2019, a jury convicted Smith of manslaughter with a weapon, and Judge Melissa Polo sentenced him to 28 years in prison. During sentencing, Smith claimed he acted out of provocation, stating that he had asked Serna not to spit on his car but was ignored.
Well, he pulled up on me and he spit on me. You know what I'm saying? After I asked him please not to do that. I don't know how come he did that.
In a rare legal development, the 2nd District Court of Appeal overturned Smith's conviction, ruling that he had been denied his constitutional right to represent himself during the trial. The court determined that this violation warranted a new trial, effectively resetting the case.
He's back at square one. He has the presumption of innocence. He can have a jury trial. He can file motions. It's as if we're starting all over. We want to make sure that everyone gets a fair trial and that, you know, all the constitutional rights are observed. And this is one of the constitutional rights that we take serious.
Legal experts emphasize that Smith is now presumed innocent again and will have to go through the entire legal process from the beginning. In May 2014, Sierra Guyton was tragically shot while playing on a playground near 28th and Clark Streets in Milwaukee. The incident occurred during a gunfight between Sylvester Lewis and Jamie Jackson, both of whom had prior criminal records. The case sparked community concerns about repeat offenders and accountability in the justice system. Sylvester Lewis, then 19, had a history of arrests dating back to the age of 12, including charges of robbery, burglary, and battery. Law enforcement linked him to at least 3 shootings after his release from a previous sentence. On the day of the shooting, he was involved in a confrontation with Jackson, which led to gunfire that struck Sierra. Following his arrest, Lewis was charged with first-degree reckless homicide. In court, he displayed a combative attitude, swearing at the judge and deputies. In November 2014, a jury found him guilty, and the following month, he was sentenced to 44 years in prison with an additional 17 years of extended supervision. Jamie Jackson, who was also involved in the shootout, had previously served a 10-year sentence for a fatal shooting in 2003. At the time of Sierra's shooting, he had been released for just over a year. Jackson was charged with possession of a firearm by a felon. In February 2015, a jury found him guilty, and he was sentenced to 5 years in prison with credit for time served, followed by 5 years of extended supervision. Konstantinos Dylann and Joanne Hori pleaded guilty to the death of Dynann's 85-year-old grandfather, Konstantinos Gus Mastakouris. The couple lived with Mastakouris in their New City home.
This is a chilling story.
According to prosecutors, Dylann admitted to causing his grandfather's death while Hori acted as a lookout. Afterward, they concealed the body. To cover up the incident, they told family members that Mastakouris had moved to Greece. Meanwhile, they used his car, credit card, and other belongings, while also selling his jewelry. For 6 weeks, they maintained this deception.
Gus bought himself a new car. Never happened. Gus went to Greece. Never happened. Why? Gus was stuffed in the crawl space.
However, concerns grew among relatives when they noticed a foul odor coming from the home. This eventually led to the discovery of the hidden body. Investigators determined that the couple had continued living in the house while benefiting from Mastakouris' assets.
You wanted your grandmother's jewelry, you wanted their home, you wanted his life.
During sentencing, the judge condemned their actions, stating that their motives were driven by greed. Prosecutors emphasized the calculated nature of their actions, but acknowledged that their guilty pleas spared the family from the distress of a trial. Dylann was sentenced to 20 years to life, while Hori received 15 years for manslaughter. When given the opportunity to address the court, both defendants chose to remain silent. Lana Clayton was convicted of poisoning her husband, Stephen Clayton, in July 2018 by secretly adding eye drops to his water over an extended period. Prosecutors revealed that the toxic buildup ultimately led to his death. As Stephen lay dying in their South Carolina mansion, Clayton took his phone away, preventing him from calling for help.
Impulsively put the Visine in Stephen's drink, and I did it with the intent to make him sick and uncomfortable. I was upset about the abuse and just wanted him to leave me alone. I never thought it would kill him.
Clayton claimed she never intended to kill her husband, arguing that she only wanted to make him sick due to alleged abuse. However, prosecutors and Stephen's loved ones rejected this claim, asserting that her actions were calculated and cruel.
He was supposed to be here now to help me figure out what path I should be on, but he's not here, and I'm struggling, and I'm not okay.
Ruthlessly, the defendant hand-delivered glass after glass of that ultimately killed him.
Medical experts testified that ingesting eye drops can cause severe health complications, including respiratory and heart failure, eventually leading to coma and death.
You can't breathe after a while, your heart shuts down, and you eventually go into a coma.
Further investigation uncovered a troubling history. In 2016, Stephen survived a head injury after being shot in the head with a crossbow while sleeping. At the time, the incident was ruled an accident, but prosecutors later suggested it was a failed attempt on his life. During sentencing, Judge Paul Birch condemned Clayton's actions, emphasizing her deliberate efforts to harm her husband and her choice to deny him medical assistance. The court sentenced her to 25 years in prison, bringing closure to Stephen's family, who expressed relief that justice had been served. James Beck and his son, Stuart, set out to sell a dirt bike they had listed on Craigslist, unaware that they were walking into a trap. They arranged to meet Takhai Johnson and Ramondre Williams in Tampa, believing them to be potential buyers. When Beck arrived and Johnson handed over the cash, he quickly realized it was not the agreed amount and returned the money. At that moment, Johnson allegedly pulled out a gun, forcing Beck and his son to run toward their truck. As Beck attempted to start the vehicle, a shot rang out, fatally striking him. His son, Stuart, later recalled the terrifying moment in court, giving an emotional testimony about witnessing his father's final moments 2 years later the incident.
Dad, I love you, man. Don't die! Don't die! Don't let go!
My dad was getting to the driver's seat and he got shot.
He gave another testimony 5 years after that incident.
He had turned the ignition over and the truck started, and then the firearm was
Okay, and who had the firearm?
the taller individual.
Prosecutors identified Johnson as the shooter, while the defense argued that Williams was responsible.
The shooter in this case was Takhai Johnson, the defendant in this case.
However, Williams had accepted a plea deal for a 12-year prison sentence in exchange for testifying against Johnson.
When he learned about just how much trouble he was really getting into, he decides to point the finger at someone else, Mr. Johnson.
After deliberation, the jury found Takhai Johnson guilty of first-degree murder. He was sentenced to life in prison without the possibility of parole. Anthony Ray Boyce, 57, is facing upgraded charges following the death of 80-year-old Earl Holland after a dispute over a parking space turned violent. The incident took place in a grocery store parking lot where both men attempted to claim the same spot. When Holland exited his vehicle to enter the store, Boyce approached him, and a heated argument ensued. Surveillance footage reportedly shows Boyce striking Holland.
Mr. Holland was backing into a parking spot. It appeared that the defendant was also trying to get that parking spot. When Mr. Holland exited his vehicle to go inside the store, the defendant approached him. They had an argument, and the surveillance video shows the defendant hitting him one time in the head, and then him falling to the ground, hitting his head on the concrete.
Holland suffered severe head injuries and was taken to the hospital, where he later passed away. Initially, Boyce was charged with aggravated assault causing serious bodily injury, but prosecutors have indicated that the charge will be upgraded due to Holland's death. The specific new charge has not yet been announced as the Harris County Sheriff's Office continues its investigation. Following the victim's passing, Boyce's bond was increased from $100,000 to $200,000. As legal proceedings move forward, authorities will determine the final charges he will face. In late November 2024, Houston police responded to an urgent call about a woman and her daughter being held hostage at an apartment on Richmond Avenue. Upon arrival, officers found 29-year-old Kendrick Raven Fisher asleep on the couch with blood on his clothing. Inside the apartment, they discovered his sister, 28-year-old Janine Fisher, and her daughter, Carly Watkins, both unresponsive. Prior to the incident, Janine had reached out to a friend expressing concern over Kendrick's erratic behavior and refusal to leave her home. The friend advised her to call 911 and later arrived at the apartment to check on her. Upon noticing and an alarming scene through a window, she immediately contacted the authorities. As details emerged, authorities uncovered a troubling past. Kendrick, 29, had been released from prison in December 2023 after serving 7 years for armed robbery. Records revealed a history of violent behavior, including prior threats against his own family. In fact, Janine had previously reported incidents involving her brother, but tragically, her concerns did not prevent what happened that night. Following his arrest, Kendrick was charged with capital murder. During a December 2024 court appearance, prosecutors described the case as deeply disturbing and urged the judge to keep him detained, arguing that he posed a severe threat to society. The court initially set his bond at $200,000, but prosecutors successfully requested an increase to $3 million.
I did ask for no lower than a $3 million bond. Somebody with this little regard for human life, somebody that's willing to stab a 2-year-old to death, is not somebody we can have walking out into society.
A bond hearing was scheduled for February 4th, 2025, during which Kendrick's legal team indicated they would be evaluating his mental health. Meanwhile, the Houston community remains shaken by the tragic loss of Janine and Carly, as loved ones struggle to understand how such a horrific event could take place. Donna Adelson is set to stand trial for her alleged role in the 2014 murder of her former son-in-law, Florida State University law professor Dan Markell. Prosecutors claim she was involved in orchestrating the crime by facilitating the hiring of 2 hitmen through her son, Charlie Adelson, who was convicted of the murder in 2023. Her previous attorney withdrew from the case due to a conflict of interest, having also represented Charlie. She has since appointed a new defense team led by attorneys Joshua Zellman and Jackie Fulford.
Joshua Zellman on behalf of Ms. Adelson.
And Jackie Fulford on behalf of Ms. Adelson.
Jackie Fulford is a strategist, and she's about getting it done. So, and her and Zellman teaming up, I think Donna Adelson made a good choice.
Fulford, a former circuit judge and interim state attorney, is expected to bring a strategic and efficient approach to the case.
Their office is going to be providing us with hard copies, or electronic copies rather, of all of the deposition transcripts, rather than trying to secure them from prior counsel.
The new legal team is currently reviewing case materials, with prosecutors agreeing to provide electronic copies of depositions and other essential documents. During a recent court hearing, the defense suggested a trial start date in mid-June 2025, but emphasized the need to receive all discovery materials.
That trial period would have been June the 16th to July the 2nd.
The judge has ordered that all relevant documents be turned over by the next case management hearing in February to ensure both sides are prepared.
It's kind of like picking up somebody's painting and not being told what the vision was or what you saw, and you're not painting something you're looking at, you're kind of painting in the blind.
The court has officially scheduled Adelson's trial to begin on June 9th, 2025. Given the complexity of the case and years of accumulated evidence, legal experts acknowledge the challenge her new attorneys face as they work to build her defense. Chris and Shanann Watts appeared to have a happy life in Frederick, Colorado, with their 2 daughters, Bella and Celeste. They were expecting a third one, a boy they planned to name Nico. However, behind the scenes, their marriage was deteriorating. Chris was having an affair with a co-worker, Nicole Kessinger, and their relationship was becoming strained. Shanann, an active social media user, frequently posted about their family life, but tensions were rising in their home. On August 13th, 2018, after Shanann returned home from a business trip, she and Chris had a confrontation. In the early hours of the morning, Chris murdered his wife and later killed their daughters. In the following days, Chris pretended to be a worried husband, pleading for his family's safe return in television interviews. However, his behavior raised suspicion. On August 15th, after failing a polygraph test, he confessed to the murders. Investigators uncovered evidence of his extramarital affair, which played a significant role in his decision to eliminate his family. As the case proceeded, Watts initially had the right to a preliminary hearing to determine if there was enough evidence to move forward with the trial. However, on November 6, 2018, he waived his right to the hearing and entered a guilty plea to multiple counts of first-degree murder, as well as additional charges related to the unlawful termination of Shanann's pregnancy and tampering with deceased bodies.
Mr. Watts will explain to you what you have been formally charged with and what the possible penalties are.
Count 1 alleges that on or about August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Shanna Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8, and that crime is classified as murder in the first degree, a class 1 felony. Do you understand? Count 2 alleges murder in the first degree, also a class 1 felony, and it reads that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Bella Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand? Count 3 alleges murder in the first degree, a class 1 felony, and specifically it alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, caused the death of Celeste Watts in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection 8. Do you understand? Count 4 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Bella Watts, a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand? Count 5 alleges murder in the first degree, a class 1 felony. It alleges that between and including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Celeste Watts, a child who had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of Colorado Revised Statutes 18-3-102, subsection 1, subsection F. Do you understand? With regard to these first 5 counts, the minimum sentence that the court could impose if convicted is life imprisonment in the Colorado Department of Corrections, and the maximum death, the sentence is death. Do you understand? Let me also point out that pursuant to Rule 32.1 of the Rules of Criminal Procedure, the prosecutor would have to file a written statement of intent to seek the death penalty no later than 63 days after arraignment. Do you understand? If a life imprisonment sentence was imposed, it would be without the possibility of parole. Do you understand that? Count 6 alleges a Class 2 felony of unlawful termination of pregnancy in the first degree. Specifically, it alleges that on or about August 13, 2018, Christopher Lee Watts, with the intent to terminate unlawfully the pregnancy of a woman, namely Janine Watts, feloniously and unlawfully terminated the pregnancy of the woman. Further, the woman died as a result of the unlawful termination of the pregnancy in violation of Colorado Revised Statutes 18-3.5-103. Do you understand? Yes, sir. The possible penalties, if convicted for this crime, is a mandatory minimum 16 years in prison up to 48 years in prison, followed by an additional mandatory parole period of 5 years. Do you understand? Yes, sir.
By waiving the hearing, he avoided a prolonged legal battle and an extensive public trial, sparing himself and the victims' families from further exposure to distressing details. In exchange for his guilty plea, the death penalty was taken off the table at the request of Shanann's family. During the sentencing hearing, Shanann Watts' father stood before the court, overcome with grief and anger. He condemned Chris Watts as a heartless monster.
You heartless monster, you have no heart or feelings or love. Prison is too good for you. This is hard to say, but may God have mercy on your soul.
Shanann's mother followed, addressing Chris with sorrow rather than rage. She reminded him of the love and trust their family had placed in him.
My daddy is a hero. He helps me grow up strong.
We loved you like a son. We trusted you. Your faithful wife trusted you. Your children adored you.
Then the time came for the sentencing.
Fair and reasonable under the circumstances. I want to acknowledge the Rusick family as well as the Watts family that showing mercy on Mr. Watts is understood. And I respect that decision to request that the district attorney not seek the death penalty in this case. And so the court is going to accept this plea bargain under the circumstances. Words that come to mind when I hear the evidence in this case are a senseless crime and the viciousness of the crime. And equally aggravating in this court's determination is the despicable act of disposing of the bodies in the manner in which they were done in this case. I've been a judicial officer now for starting my 17th year, and I could objectively say that this is perhaps the most inhumane and vicious crime that I have handled out of the thousands of cases that I have seen. And nothing less than a maximum sentence would be appropriate, and anything less than the maximum sentence would depreciate the seriousness of this offense. So the court is going to sentence Mr. Watts as follows. With regard to count number 1, murder in the first degree as it relates to Shanann Watts, the court is going to sentence you, sir, to a life sentence in the Colorado Department of Corrections, followed, with no possibility of parole. And that is going to run consecutively to all but counts 3 and 4. With regard to count 2, as it relates to murder in the first degree with Bella, the court is going to sentence you to life in the Colorado Department of Corrections with no possibility of parole. With regard to count number 3, the court is going to sentence you as it relates to Celeste to life in the Colorado Department of Corrections with no possibility of parole. With regard to counts 4 and 5 relating to Bella and Celeste as a different theory of first-degree murder, the court is going to sentence you to life in the Colorado Department of Corrections, and legally those sentences must run concurrently as a different theory of first-degree murder. Recognizing the unlawful termination of pregnancy for the unborn child that has been named Nico, the court absolutely believes that the maximum sentence of 48 years would be appropriate to run consecutive to the other charges, with an additional mandatory parole period of 3 years as set forth by statute. With regard to count number 7, as it relates to tampering with a deceased body, as well as counts 8 and 9, each a class 3 felony, the court is going to impose a maximum sentence of 12 years each for those counts to run consecutively to the other counts.
He was sentenced to 5 life sentences without the possibility of parole, along with an additional 48 years for unlawful pregnancy termination and 36 years for tampering with the bodies. He is currently serving his sentence at Dodge Correctional Institution in Wisconsin. While behind bars, Chris has attempted to shift the blame for his crimes. In recent letters and interviews, he claimed his wife was controlling, suggesting that he felt trapped in the marriage and that the affair was a way to escape. At times, he even blamed his mistress, referring to Nicole Kessinger as a Jezebel and insinuating that she had influenced him. Despite these statements, his initial confession and overwhelming evidence confirm that he acted alone in planning and carrying out the crime. Ashley Elkins, a 30-year-old mother from Warren, Michigan, had an unsettling encounter on December 31st, 2024, when her ex-boyfriend, DeAndre Booker, scheduled an appointment at her home salon under a fake name. When she realized who it was, she quietly instructed her family to remain silent until he left. On the morning of January 2nd, 2025, Ashley left home around 8:30 a.m., dressed in a long black coat with fur around the hood and black leggings. She told her family she had errands to run, but never returned. Her phone's last known location later placed her at Booker's apartment in Roseville. 5 days later, authorities found her gray Chevrolet Malibu abandoned a few miles from his residence. A search of his apartment revealed evidence of a violent encounter, raising serious concerns about her safety. The following day, Booker was arrested in Flint, Michigan. Investigators discovered he had searched the internet for ways to flee the state, erase digital records, and avoid detection.
Mr. Booker, did you talk to Mr. King today?
Yes.
Did he go over your rights with you?
Yes.
Did you understand all of those rights?
Yes.
Do you have any questions regarding your rights?
No.
I'm going to enter a not guilty plea for purposes of arraignment. With regard to bond, we'll start with Mr. King.
Your Honor, Mr. Booker is 32 years old. He's in custody on this charge. He states he is not employed. He lives at the same address. He also states he's not on probation or parole. I'd recommend a reasonable bond in this matter.
All right, and Mr. Fox.
Thank you. Good morning, Your Honor. Obviously, we're here on a 4-year felony for lying to a peace officer on a violent crime investigation. This is, of course, as Your Honor is aware, involving Ms. Elkins. And the court is to consider MCR 6.106F and MCL 765.6, a number of factors. I'm going to hit on a few if you don't mind. The first is the protection of the public. The underlying matter, although not the charge specifically, but the underlying matter obviously involves a crime of violence, potentially. We are still seeking Ms. Elkins. The defendant, we suspect and believe, may know where she is. And a concern is her safety if, God forbid, the worst has not happened yet. So with respect to that, Judge, I believe that there is a risk to the public, specifically if she were still alive, and that's what we're all hoping for, of course. The other is the defendant's risk of non-appearance and the likelihood of conviction. Likelihood of conviction, Judge, the defendant made several material factual misstatements to Detective Lasprins and recited those to the court during the course of the initial swear-to. The defendant was aware that we were investigating a missing persons report. He was aware that there was some belief of his involvement. He made misstatements about both his location as well as Ms. Elkins and how she may have left his vehicle, left his apartment complex, all of which we can demonstrate by objective evidence and video evidence to be false. So there's a high likelihood of conviction on these cases, on these matters. And then last and most importantly for the court's consideration, I think at this point, is the probability or improbability of returning for trial. We have a history that includes charges at least. We do not have the disposition, but we did recover DD 214 from his time in the U.S. Army. It looks like in 2016 he was charged with a couple of matters, including larceny of private property and, more importantly, fraudulent ID documents. And then in 2017 he was charged with desertion or the absence without leave, going AWOL from the Army. Ultimately, he was discharged less than honorably, although it was not a dishonorable discharge. He was discharged from the Army in a less than honorable means or manner. We know that after the conversations, before the conversations with Detective Lesperance, but we believe after the underlying events of this case, he fled from Macomb County, went to Flint, where he was apprehended and brought back to Roseville. And we know that during that time, while he was in Flint, he accessed the internet to search for such things as fastest routes from Flint to Ohio, what to do on the run, is blood traceable, how to beat a polygraph, and deleting Google history. So Judge, I think by his own words and search history, by his prior conduct, and by what is frankly at stake in this particular matter, he's of significant risk of flight. With that, I would request a significant bond. I'm asking for a $500,000 cash surety bond, no 10%, and that a steel cuff GPS tether be attached should he make that bond.
All right, Mr. King, anything further from you?
Nothing further, Your Honor.
Detective Lesperance, is there anything you wish to add?
No, ma'am, not this time.
As Mr. Fox indicated, there are many things the court has to look to with regard to setting bond and determining bond. This court looks most closely at the risk of harm to the public and the likelihood of the defendant's appearance in court. I will note for the record that this matter is currently charged as a 4-year felony. I will also note for the matter that while Mr. Fox did point out several instances from the defendant's time in the military with regard to any sort of matters that came up with regard to larceny or desertion, that there is no other criminal history presented. But that being said, the matter being investigated does involve a missing person, which is a very serious matter. And the court takes very seriously that the allegations being made are that the defendant is lying to a police officer regarding material facts about a missing person at this time. That gives the court great concern about the risk of harm to the public and the likelihood that the defendant will make sure that he appears in court for both this matter and any potential further charges that may be brought by the prosecution. At this time, the court is going to assess an amount of bond in the amount of $250,000 cash surety, steel cuff tether prior to any release. The PCC date in this matter will be January 22nd, 2025 at 8:30 a.m. on Zoom in front of Judge Bodecker. The exam date will be January 29th, 2025 at 8:30 a.m. in person in front of Judge Bodecker. I have referred the matter to the Office of the Public Defender for appointment of counsel at this time. If the defendant does retain counsel, that counsel can send in a substitution of attorney.
On January 9th, Booker was formally charged with lying to the police. During his arraignment, prosecutors detailed his history of deception and his online search history, arguing that he posed a flight risk. The judge set his bond at $250,000, with a requirement for GPS monitoring if released. As the investigation progressed, authorities focused their search on the Pine Tree Acres landfill in Lenox Township, believing it might hold clues to Ashley's fate. The search lasted nearly a week, but did not yield any major findings.
We conduct a search warrant on the residence and ultimately find what we believe to be a large crime scene with a substantial amount of blood in the bathroom. DNA confirms that the blood did in fact belong to the victim.
By the end of January, DNA evidence confirmed that blood found in Booker's apartment belonged to Ashley.
Sir, you are charged with count 1, homicide, murder, first-degree premeditated.
With this development, the charges against him escalated to first-degree premeditated murder, tampering with evidence, disinterment of a body, and concealing a death. Ashley's uncle and mother felt relief after he was charged with first-degree murder.
Fortunately, they were able to charge first-degree murder, which is what the family wanted, because that means mandatory life in prison. So that's a major relief, major relief.
I can sleep a little better at night. Knowing that he's going to go to prison for the rest of his life.
On February 5th, Booker appeared in court again. Both the prosecution and defense requested more time to review evidence, and the judge rescheduled the next hearing for March 7th. Meanwhile, Ashley's family continued to organize vigils and push for justice, while her 2 sons struggled to understand why their mother had not come home. The investigation remains ongoing, with authorities urging anyone with information to step forward. In Judge Middleton's courtroom, an unusual case unfolded. Adam Joseph Waldron stood accused of attempting to influence jurors, an offense rarely prosecuted. His alleged crime took place during a break in his own trial when he spoke with his family in the courthouse stairwell. Frustrated, he badmouthed about the trial, unaware that a juror was within earshot. This led to a mistrial, and he faced new charges.
Versus Adam Joseph Waldron. That's you, sir?
Yes, sir.
You're charged here with attempting to influence jurors. You did willfully attempt to influence the decision of a juror in a case or argument that was not a part of the proceedings in open court. They charge this as a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. I haven't seen this case charged in many, many years, but it is still on the books. The prosecutor has agreed to reduce that to a charge of attempting to influence a juror. There is no
an attempt to influence.
I don't know if there is such a thing. I don't think there's an attempted attempt. The attempt would be 180 day, but I don't think you could do an attempt of an attempt. You've been in custody for 64 days. So attempt to attempt, I don't think that's a valid charge. So it'd have to just be attempt, which would be a 180 day maximum offense and a fine of up to $500. Do you understand?
Yes, sir.
Other than that plea offer, did anybody promise you anything to get you to plead to this?
No, sir.
Or threaten you?
No, sir.
During the hearing, Judge Middleton outlined the charge: a misdemeanor punishable by up to a year in jail and a fine. The prosecution offered to reduce it to an attempt charge, but the judge questioned whether an attempt to attempt is a valid charge. Ultimately, Waldron was formally charged with attempting to influence jurors, which carries a maximum penalty of 180 days in jail and a $500 fine.
Now, I heard about this when this went down. Judge Stutzman was not very happy about this.
Yeah.
You were having a trial on a resisting and obstructing charge, is that correct?
Yes, sir.
And then before the jury had reached their verdict, did you have some discussion with the juror in the stairwell?
No, sir.
Tell me what happened.
I was actually talking to my family. Like they're here with me today. My dad was on the left, she was in the middle, and I was on the other way around. My dad was on the right, my dad's old lady was in the middle, and I was on the left. I was talking to her the whole entire time. All right, well, were you talking about how unfair all this was, and there was all travesty of justice, and the jurors were there? No.
Well, all right, let's take a look at the affidavit and see what that says. Spoke to Dina Rose. She was a juror in the Adam Waldron trial. She was in the stairwell at the courthouse, talking loudly about the trial and how they thought the evidence presented was bullshit. Dina said at the bottom of the stairs was another juror, and the defendant spoke directly to that juror. Also, the other juror was anyway, this was a security breakdown. This shouldn't have happened anyway. But apparently you were expressing your opinion about your trial and the jurors were present in the hallway when that happened.
No, I was talking to my dad.
Okay, you were talking to your family, but it was within the earshot of the jurors.
They shouldn't even be around me.
Your Honor, it doesn't sound like we have a plea.
Yeah, I wouldn't argue with that either. In order to do this, you got to admit that you did something wrong. It says here, you're saying this trial is a bunch of bullshit and the jurors were there and they were uncomfortable by it. Now, you can certainly express your opinion to your parents about that.
Yes, sir.
You can say whatever you want. But they ended up having a mistrial and had to start all over again.
Yes, sir.
So the judge was not real happy about
Yes,
this.
sir. I would like to be honest with you, I like to try to get a dismissal on this case.
All right, well, they don't want a dismissal. What they were recommending, I think, is time served.
When asked about the incident, Waldron insisted he was only talking to his family and never directly addressed a juror. However, court records indicate that his comments were loud enough for multiple jurors to overhear. The judge acknowledged that this situation resulted from a courthouse security failure, but emphasized that the consequences, forcing a mistrial, were serious.
So, but at this point, you haven't acknowledged anything. Another option is you could plead no contest to this charge. By pleading no contest, you don't admit what happened. You also don't deny it, and you would allow that a conviction would enter. Are you willing to plead no contest to this charge?
Yes, sir.
All right. Have you been sentenced on your other cases yet?
No.
It's still pending. I know Mr. Knopfsinger's his attorney. I've been reaching out to him as far as a status update on that. I know he's still in negotiations with the prosecutor.
I was just trying to be done with no. I know I talked to Luke. He came to see me last Thursday, and he said he would dismiss this charge and plead the R&O down to a misdemeanor and get time served, no probation.
That's not the information I received, Your Honor.
Well, I don't need to know that. I don't know what it is, and unless the matter is resolved this year, it'll be in the province of the new prosecutor. I'll show this as a no contest plea. The very first case I tried in December of 1981.
I wasn't even born. I wasn't even born.
I get that a lot.
I was born in 95.
It was a very complicated case involving a set of identical twins and a fraud, and it had 76 exhibits and 27 witnesses, and I'd had my bar card for about 2 weeks. But I'd worked on it the whole summer before. I did the whole trial, and one of the jurors made a date with one of the witnesses in the parking lot. Her car wouldn't start, and he went over to jump her car. And they started to talk, and he was married. Anyway, they made a date to meet after the trial was over. So I tried the whole thing. The guy was convicted. It came to light that one of the jurors had made a date with one of the witnesses, in fact, one of the key witnesses, and the case was mistried. So it was a big mess. Ultimately, he did get convicted, but the case was reversed for other considerations. Craig David Neeland was the name of the defendant. I won't say the name of the juror or the witness.
Your Honor, could I ask for sentencing purposes that any allowable fines and costs that the court can waive be waived?
Yes, I'm going to order 63 days in jail, credit 63 days. This is another one where this case doesn't make a lot of difference. The minimum fine of $125 for 2 additional days. Once again, Mr. Waldron, just about everybody this morning that's been in custody, we took care of a matter as one less thing they have to worry about.
Yes, sir.
I would suggest in the future, you wait till you get out of the courthouse, in your car, say whatever you want.
Yes, sir.
Don't do it in the hallway in front of several jurors.
Yeah, my word.
Initially, Waldron sought to have the case dismissed, but the prosecution refused. He then agreed to enter a no contest plea, meaning he neither admitted nor denied guilt, but accepted the consequences. The judge sentenced him to 63 days in jail, with credit for time served, effectively closing the case. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.